And now it is my great pleasure to invite Professor Diego Garcia Sayan, the Special Rapporteur of the United Nations on the independence of judges and lawyers. Professor Diego Garcia Sayan was judge in the Inter-American Court of Human Rights, was a minister of Foreign Affairs of Peru, and now is serving in this very important function of Special Rapporteur on the Independence of Judges of the United Nations. Professor Sayan, the floor is yours.
Good afternoon, ladies and gentlemen. I am having some problems with connection, so I haven't heard the last parts presentation made by my good friend Shimon Shitrit. So anyway, good evening, good afternoon, Professor Shimon Shitrit, distinguished participants, distinguished lectors of today. Really, I am, first of all, I would like to thank for the opportunity to be with you today. Although the unfortunate coincidence with a never-ending pandemic has prevented me from participating in person in this extraordinary meeting at the Hebrew University of Jerusalem. I am in Lima, Peru, a little bit far away from Israel, unfortunately, and I hope that there will be an opportunity in the future to be present in person at this prestigious university. I must express, first of all, my special appreciation and thanks to Professor Shimon Shitrit, the leader of the International Project on Judicial Independence, sponsored by the Hebrew University of Jerusalem Faculty of Law and the University of Cambridge Center of Public Law. The objectives of this project and the leadership of Professor Shitrit ensure its relevance and significance in affirming judicial independence in the world, an essential component of a democratic society respectful of fundamental rights, as it has been mentioned in the previous presentations. Professor Shitrit has been a pioneering voice in the world in the last decades, since he highlighted the fundamental relevance of judicial independence and accountability 40 years ago on the occasion of the first Judicial Independence Conference held in Israel 40 years ago. That was a pioneering milestone in substantive conceptual developments on the subject. I welcome serious and consistent efforts such as this one, and I am grateful to be invited to share some thoughts as one of the many democratic wills in the world to enforce respect for fundamental rights and institutions such as the judiciary called upon to guarantee them. Dear colleagues and friends, as all of you are perfectly aware, independence of the judiciary is an essential component of a democratic society. I welcome all the concepts that have been expressed in the previous presentations about the positive evolution in Israel in the last decades. It has to do with the rights of all, and it is not a prerogative or privilege granted in the interest of judges or lawyers. It is justified by the need to enable them to fulfill their role as guardians of the rule of law and of the human rights and fundamental freedoms. International standards provide that it is an obligation of all governmental and state institutions to respect and observe the independence of the judiciary and to adopt all appropriate measures to ensure that judges can decide matters before them impartially and without improper influences, pressures, or interference. As such, independence of the judiciary should be regarded by every citizen as a guarantee of truth, freedom, respect for human rights, and impartial justice free from external influences. The United Nations Basic Principles on Independence of the Judiciary were adopted at the UN in 1985, more than 36 years ago. They are the crucial international standard in this endeavor. As you all know, this international instrument is composed of a solid set of guidelines so that member states ensure the establishment and recognition of judicial independence in their home countries. In fact, they list the measures that states are required to adopt to guarantee the independence of the judiciary at the national level. The preamble of the basic principle establishes the obligation of governmental institutions to respect the independence of the judiciary, obligation, as well as their duty to take all appropriate measures so that judges can decide matters that are submitted before them, so that judges can decide their cases impartially and without any undue influences, pressure, or interference. The basic principle established among other standards: A. Independence of the judiciary. B. Judges' freedom of expression, belief, association, and peaceful assembly rights. C. Standards to determine their professional background, selection, process, and training competences to fill a judicial position. D. Conditions of service and tenure. E. Third, their duty to keep professional secrecy and judicial immunity, as well as F. Disciplinary measures, suspension, and removal from office. Dear colleagues, over the past years, United Nations bodies such as the Human Rights Committee have strengthened the scope of the basic principle through subsequent resolutions that have interpreted and complemented its scope. For example, in its General Observation number 32, the committee established that the requirement of the competence, independence, and impartiality of a court is an absolute right that could not be subject of any exception. Distinguished participants, the original notion of the UN Basic Principles derived from the idea that institutional independence meant essentially that judicial systems had to be independent from other branches of government, mainly the executive or legislative branches. Such fundamental concept, of course, continues to have full and total validity and constitutes the foundation of the rule of law and is also essential for the respect of human rights. For example, the fundamental right to a fair trial would be illusory without an independent and impartial tribunal. However, unfortunately, attacks on judges, lawyers, and court officials is part of an unaccountable situation in which separation of powers is replaced by power concentration, authoritarianism, and human rights violation in several countries in the world. That context and situation led the then Commission on Human Rights, now Human Rights Council of the UN, to establish in 1994 the mandate of the Special Rapporteur on the independence of judges and lawyers, noting both the increasing frequency of attacks on independence of judges, lawyers, and court officials, and the link which exists between the weakening of safeguards for the judiciary and lawyers and the gravity and frequency of violations of human rights. Like other mandates, this one was assumed later by the Human Rights Council, which replaces the Human Rights Committee. The Human Rights Council, its mandate even reviewed and strengthened and extended for periods of 3 years. Under the mandate of the Special Rapporteur, he or she is requested to inquire any substantial allegations and to report conclusions and recommendations thereon, to identify and record not only attacks on independence of the judiciary, but also threats and questions of that can eventually affect that independence, and of course, progresses achieved in protecting and enhancing independence. As well, to identify ways and means to improve the judicial system and make concrete recommendations for that end. As well, to study for the purpose of making proposals important and topical questions of principles with a view to protecting and enhancing the independence of the judiciary and lawyers and court officials. To apply as well a gender perspective, to report regularly to the Council in accordance with this program of work, and annually, as I do each year, to the General Assembly of the United Nations. In the discharge of these functions, the Special Rapporteur acts on information submitted concerning alleged violations related to the independence, impartiality of the judiciary and independence of the legal profession, and also on the basis of that information sends allegation letters and urgent appeals to concerned governments to clarify or bring these cases to their attention. The Special Rapporteur as well conducts country visits upon the invitation of the relevant government. The Special Rapporteur submits, after that visit, a report to the Human Rights Council presenting findings, conclusions, and recommendations. The last visit I made was to Uzbekistan. Unfortunately, following the pandemic, it was very difficult to make visit last year, and the next visit will be to Bolivia in the month of February this year, in a couple of weeks from now. The Special Rapporteur presents annual thematic reports to the Human Rights Council in the June session and to the General Assembly of the UN, highlighting important issues that the Rapporteur selects for areas of concern related to the mandate. I met the Malaysian jurist Dato Param Kumaraswamy, the first Special Rapporteur in Lima in 1996, when he was in official visit to Peru, so to examine the violations on independence of justice that were being committed by the authoritarian government of Fujimori in my country after his self-coup in 1992. I didn't suspect it then, after 2 decades, that I was going to receive that responsibility by the UN. By decision of the Human Rights Council, this has been assigned to me since December 2016. I have devoted since as Special Rapporteur to identify and record attacks on the independence of the judiciary, lawyers, and court officials, and as well monitoring the compliance with international standards adopted by the United Nations, such as the UN Basic Principles on the Independence of the Judiciary adopted in 1985. But the specific rules and global standards on independence of judges and lawyers were established, as I was saying, in 1985 when the basic principles were adopted by the UN. They were complemented 5 years later with the basic principles on the rule of lawyers and the guidelines on the role of prosecutors adopted in 1990 at the United Nations. Despite such a comprehensive legal framework, we have to add regional standards, regional courts in Europe or in Latin America, and a valuable body of jurisprudence. The independence of judges and lawyers and prosecutors is still extremely vulnerable, under attack, or is merely non-existent in several parts of the world. And new challenges continue to appear, as we are seeing right now in the recent experiences in Afghanistan. That is why reviewing and strengthening the basic principles with a view to recommend concrete ways to render such independence more effective seems timely. Attention should be made to the evolution in which independence has to be assured and preserved and address the commitments. The basic principles have been a fundamental safeguard. However, at this point, they are being enriched, and for that endeavor, this Special Rapporteur has been advancing a variety of proposals to UN bodies and to civil society. As a consequence, in fact, the content is being strengthened by additional steps based on serious threats and contemporary challenges that were not severely present when they were drafted and adopted several decades ago. The most relevant one is the threat of corruption and the function that an independent judiciary must play to confront corruption. As a Special Rapporteur, I have been systematically recommending that the international community promotes initiatives aiming at establishing the necessary link between the UN Basic Principles on the Independence of the Judiciary, the Bangalore Principles, and the UN Convention Against Corruption. This effort is crucial so that the UN Basic Principles be interpreted in conjunction with international instruments such as the guidelines of the role of prosecutors, the Bangalore Principles, and this Convention against corruption. A very positive evolution has taken place in the last months to promote an interaction between independence of lawyers and the implementation of the UN Convention Against Corruption, one of the most important and relevant international treaties adopted in the last decades. Since my first report, presented from 2017 on to the General Assembly in the Human Rights Council, I have promoted this essential interaction, as well with the Bangalore Principles and accountability. I established, for instance, in my report of that year to the Human Rights Council that, I quote, corruption affects the respect for the protection for human rights and calls on states to prioritize this issue. Being free from official corruption must be one of the major components of of a judicial independence. At the General Assembly that same year, I stated in my report that as it is a key tool to address corruption, the Convention Against Corruption should also be seen as a fundamental international instrument for the protection of human rights, and it therefore warrants continued attention from the relevant competent bodies. That initiatives are being matter of close follow-ups and for some in having some encouraging results and impact. For instance, in the Conference of State Parties of the Convention held last year, part of the consequences was that special recognition was, I quote, one of the most effective ways to prevent and combat corruption is to uphold the independence of the judiciary and ensure effective oversight, investigatory, prosecutorial, and judicial institutions that enjoy protection from undue influence and have access to and all relevant information, finish quote. In the same resolution adopted by the state parties, it was clearly mentioned the contribution of basic principles, independence of the judiciary, guidelines on the roles of prosecutors, and the Bangalore principles which were especially recognized. Dear friends, I have to end because time is elapsing, it's a little bit late there in Jerusalem, mentioning how this process of strengthening judicial independence, as you are all aware, and I have mentioned at the beginning of my presentation, has to do with public interest, with the needs of society, and to prevent and to attack contemporary challenges as the increasing corruption or international corruption taking place in several parts of the world. Then on, so to discuss all these matters in this very important conference is very timely, and I want to express my support again to the fantastic work that Professor Chitrit is being doing in the last decades, and my deep appreciation for the kind invitation to be with all of you today. Thank you very much, and hope that we can see each other personally in some moment in the following months or eventually years. Thank you very much.
Many thanks for this presentation, Professor Diego Garcia Sayan, and for your contribution to improve the system of government in the world and the quality of judicial process and human rights in our very troubled world in many parts of this globe.